Just super quick, huge fan of it. Footnote 140, where you say Blackstone talks about due process of law, but oh, that's just this death penalty context. I think that is a super important context that you really must discuss in some detail. He says you can't impose the death penalty retroactively. The 1354 statute guarantees that any death penalty has to be done with express warrant of law that gives the people the opportunity to guard their conduct and not get executed. And I mean, it seems like that is very powerful evidence that it's a general legality principle. I think you can put that in terms of writs by saying, well, it's not just having writs, but it's answering the questions that the writs ask. Okay, so Sixth Amendment compulsory process, I think definitely important context, but what is a writ? It's asking a question, and that presupposes a method of answering that question and pursuant to pre-existing law. I think that seems to be the presupposition that Blackstone has, and that seems plausible to me. So,
all right, Peter Smith.
So thanks for sharing this paper. Really interesting. Just a quick thought on your account. The due process clause applies to both civil and criminal cases. By its terms, the requirements of the clause are triggered by a deprivation of life, liberty, or property. Two of those things are most obviously and maybe uniquely only relevant in a criminal proceeding. And yet another clause of the Fifth Amendment, which Tara mentioned, the grand jury indictment clause, seems to do exactly the work I think that you're suggesting the due process clause does, right? Because the indictment, as I understand it, would be the triggering process required for the government to proceed to a prosecution that would eventually potentially deprive a person of life or liberty. And so why doesn't the existence of the grand jury clause cast significant doubt on your reading, which I think makes the due process clause redundant in most of their, or at least many of the cases to which it would apply?
All right, John McGinnis.
Yes, well, I very much enjoyed this paper, which I see as part of a larger trend in fixing the meaning of the Constitution through looking at law at the time. But I want to ask, and specifically to Larry, how this lines up with his theory of looking at the Constitution in ordinary meaning, because this is not a case, the due process of law, like habeas corpus or letters of marque, which is obviously a technical meaning on its face. Indeed, I don't think it's only a matter of linguistic drift, but due process can mean fairness, I think, to someone. And therefore, in ordinary meaning, you might think this would not actually be a legal understanding. You try to address that by saying, well, in the context of the entire Fifth Amendment, there are a lot of other legal terms there, and so that should put people on notice. This is a legal term. But as you know, Mike and I have looked through the entire Constitution, have argued that there are hundreds of possible legal and possibly legal terms. And the argument there would be everyone's on notice for the entire Constitution that these terms may be legal, and therefore you have to understand the legal background to make a distinction about whether something's ordinary or legal meaning. Now, I don't doubt that you have answers to that, but I do think that it deserves, particularly given your strong views on this methodological matter elsewhere, a bit of greater discussion in the paper than it has at the moment.
I'll take John McGinnis's question, and then Max, I think, will comment on Chris Green and Peter Smith. So, John, absolutely, this is a provision that had technical meaning. So, my version of public meaning originalism allows for that possibility in two sorts of cases. The first kind of case is the case where the phrase would have been seen as having an exclusively technical meaning, and perhaps letters of marque and reprisal is like that. And the second case is where there is ambiguity as between ordinary meaning and technical meaning, and the context suggests that it was a technical meaning. And then then my theory, Max doesn't have to be blamed for any of this. My theory says that in a third sort of case, ordinary meaning, technical meaning, ambiguity, where the ambiguity would have been undetectable to the public, that we ought to go for normative reasons with the ordinary meaning. So that's the framework. So this is a case where I think that there's a very strong indicia that the public would not have seen this as a case of ambiguity. They would have seen this as a case of exclusive technical meaning. Today, this phrase is in the vernacular. Due process of law is used all the time by ordinary people, but that just was not the case in 1791. This phrase was extraordinarily rare and used almost exclusively in legal contexts. So I think that the ambiguity between the contemporary ordinary meaning and the 1791 technical meaning, just that ambiguity just didn't exist. That's a backwards projection. And I absolutely recognize that this is a case where it is technical legal meaning. And so there's no question about that. This is not the kind of case that would generate any inconsistency between your theory and my theory. It's consistent with both views.
So I'll jump in and start with Peter's question, which I thought was a great question, and I'm glad to tackle that head on. In the original English statutes, which we did not assign as the reading, the phrase due process of law is used interchangeably with other phrases such as indictment, presentment, or matter of record. And we see, and so it's not just limited to the indictment itself, it could include a matter of record, which is roughly similar to, without taking a position on this, I understand it to be similar to an information or presentment before justices. And indeed, that's the manner in which this phrase is deployed in the New York Rights Act of 1787, where it is used to mean either presentment before justices or matter of record or of similar civil process. And so that means that the due process of law clause in the Fifth Amendment is not redundant with the grand jury clause. Rather, the grand jury clause requires a higher showing in the federal context than that would be generally required by the due process of law provision. And this brings to mind Hurtado v. California, in which the court was confronted with the question of whether a presentment whether an information rather than grand jury indictment was permissible under the 14th Amendment. And we would say that while that wouldn't be permissible under, again, without taking too much of a position on this, but just as I think about it, while that wouldn't be permissible under the federal, in a federal court due to the grand jury, it would be permissible were that clause not there. Turning to Chris Green's comment, I've not looked at the part of Blackstone that you're specifically quoting there, but I think that's a really interesting comment, and I certainly will, because I can see the normative power of that argument. I will say that we did expand that discussion of Blackstone a little bit in the draft we actually submitted for law review consideration, but I can see that very easily fitting into that section, and I would be delighted to include it. I'll have a look later.
Okay, the next troika here is Judd Campbell, Ian Werman, and David Upham.
All right,
So-
thanks. So I'm curious whether the founding era and earlier English view of rights declarations as being declaratory rather than in a sort of more positivist way of thinking about rights declarations as creating rights has any relevance. So the relevance I'm thinking of here might be in terms of the historical materials that the founders were aware of, the various English statutes. Are those merely declaratory of fundamental rights? Or do they actually create the fundamental rights, so to speak? And then also the materials that you're talking about in 1787 and then the creation of the Bill of Rights being potentially declaratory, in which case I just wonder whether in light of that, there's a sort of, there's just a lot less at stake in deciding whether to say due course of law versus due process of law. Yes, maybe there is a difference. I think it's a really interesting debate there. But if rights are merely declaratory and there are fundamental customary rights that exist, sort of to Chris's point, once you get into a common law court, like a whole bundle comes with it. And so I just wonder, both on the kind of English experience side and the American experience side, whether that declaratory rights view matters to your evidence and potentially to your implications.
All right, Ian?
My question actually piggybacks nicely off of Judd's. There's no doubt that if you're correct, the implications for modern doctrine, modern doctrine is clearly inconsistent. But my question is, how is this different from other originalist scholarship on due process of law that says it isn't substantive, like the Chapman-McConnell view? So my question specifically is, would anything be any different from an originalist perspective if the Fifth Amendment said, by due course of law, or according to the law of the land? Would anything be different? Because it's not clear to me, because the process, the writs allowed an answer. That's the whole point of the writs. We see this in the Petition of Right, when they're complaining that the writ of habeas corpus wasn't given, so that the five knights, right, in the five knights case, could not make answer according to law. So due process of law triggers the course of the law under which your life, liberty, or property are adjudicated according to the substantive law of the land, whatever that happens to be, right? So just to focus this question, the last sentence of section 2, this is on page 12, just before section 3. As written, the clause guarantees the rule of law. It does not, however, impose substantive constraints upon the government's powers or entitle citizens to any procedural rights beyond those enumerated in the Constitution and enacted into law by Congress. Can't you say the exact same thing if the Fifth Amendment said by due course of law or according to the law of the land instead of due process of law? Why is this distinction so important?
David?
Great paper, extremely thought-provoking. 2 points. One is related to what Ilan was just saying. Doesn't the necessity of answer from the words in 1354 to going forward presuppose that the process has to have a substantial interlocutory character? It has to be something that someone actually says something to which you can make an intelligible response. There probably cannot be, it's the will and pleasure of the king or the majority that you die, because how do you respond to that? I don't know. I suppose that's such an obvious thing that there'd be conversation before the killing or the imprisonment or confiscation, but it's not simply notice, but to notice in a hearing. It just seems to be there's got to be some sort of thick element there. And the second is this word mesne process. I just point something out that may have no, may be irrelevant, but it may be very relevant to the linguistic development. And that is, I was looking up mesne, and it is a kind of sense of middle, but it's also the word, it's also the past participle in the 1354 statute, which says sans estra mesne, whatever, but that's being put. So mesne may have just some kind of interesting meaning in the way it's been it developed over the several hundred years between the 14th and the 18th centuries. Thank you.
Thank you for all those comments. They're all terrific. I want to say something about Elon's comment, and then Max may want to address Judd and David. So how is it, so Elon asks, how is this different in terms of its effect on doctrine than a theory, what we call the legal procedures theory, right? So given that there are other provisions in the Constitution, so I think that there are important differences if the other relevant constitutional provisions that govern other stages in the process are given their original meaning. And so, for example, I think a return to the original meaning of the Seventh Amendment, right, which, you know, requires the preservation of the right to jury trial at common law, has important implications for what hearings are required, for example. But there may be substantial areas where the theories overlap. And then I just want to say, I think it's very important that we get the reasons right. That is, from an originalist perspective, we want to know what the original meaning of the relevant provisions are. We want judicial opinions to use reasoning that is correctly based on that original meaning.
So I'll jump in by starting with David's question, which I both enjoyed receiving and will enjoy talking about. So first, mean process did change significantly over this period. With the decline in the issuance of original writs from the Chancery, what has happened over centuries is that more and more lawsuits are initiated on judicial writs, summonses, rather than going to the executive and purchasing a writ to start it. So the phrase did certainly change, though I'm not sure that that touches on our theory. I will certainly, it's been a while since I've looked at the law French in which those Edwardian statutes are written, so I will certainly check back in on that. But as I sit here today, I don't think that changes our theory. As to your point that there just has to be a richer meaning and a thicker meaning to due process of law, I agree. I'm not sure, though, that that thicker meaning applies to the adjudicatory steps which follow the issuance of process. Rather, that thicker meaning, as I understand it, and we have attempted to flesh out in the paper a little bit, again, mostly in the part that wasn't assigned, because this is simply where the issue came up more historically in English constitutional tradition, is that it had a jurisdictional connotation as well, meaning that yes, you have the right to respond on law before a court. Not necessarily, apologies, I should be more careful with what I say. Not necessarily that you have the right to respond, but rather that the cause for which you are being adjudicated as contained in the writ must be adjudicated before a court. The method by which those the procedure that is used to make that determination is not something that itself is contained in the due process of law clause, though. Turning to Judd's point, what a fantastic question. And also what a complicated question. And I'm very hesitant to step too far into it. Both because I'm aware that there is some debate over how colonial Americans understood these declarations of rights, and indeed how the English understood their declarations of rights. What I will say is that we primarily survey these declarations to determine what the speakers or the right authors understood the phrase due process of law to mean, rather than to determine whether or not that should have the force of law. And so I think your question is an important question, but again, I don't think it necessarily changes how I see the evidence that we've presented in this paper. But I'll leave to Larry, of course, to say if he has a different view.
Yeah, and Judd, thank you. Just a terrific question. And as soon as you started asking it, I saw the connection with your important work. Well, we need to think about this.
Okay, the next three, and we have 33 minutes left. Don Dripps, Gary Lawson, and Will Bode.
So this is thought-provoking stuff. I applaud that. I'm a bit of a skeptic about it, particularly about the distinction between law of the land and due process in the antebellum sources. But let me just, I guess my point here is to run through some sources I thought should have been discussed and were not, starting with the act to abolish the Star Chamber in 1641, which invokes Magna Carta in the 6 Acts, and then goes on to castigate the Star Chamber for all kinds of things other than its failure to use just indictments. Second, James Otis's argument in the writs of assistance case in 1761, where he says that even if statutes authorize these general warrants, those statutes would be void because they're contrary to Magna Carta and the 6 Acts. Benjamin Franklin testifies in 1766 and appears in the Commons to argue against the Stamp Act because it's contrary to Magna Carta. Taxation without representation is void because it violates Magna Carta. Calhoun in 1836, debating the gag rule in the Senate, says that abolishing slavery in the District of Columbia would violate due process. Salmon Chase in 1846, inveighing against the Fugitive Slave Act in a pamphlet, says substantive due process prohibits enforcing the Fugitive Slave Act. And finally, Bloomer against McEwen, which is an 1850 decision of the Supreme Court about a patent issue about whether construing the patent license in one way or another was a deprivation of property. Tawney, perhaps setting up Dred Scott, says that would violate due process to take somebody's right to use the machines away. And so there's just a lot of stuff in there that I would like to see how you handle those data points.
Gary Lawson.
Thanks. Yeah, just very quickly riffing on Tara's and others' point about the implications. It's not just looking at the rest of the Bill of Rights, it's looking at the original Constitution as well. What's the world of executive and judicial action look like on December 14th, 1791? What that was constitutional on that day suddenly became unconstitutional the next day when the Fifth Amendment was ratified. Or put another way, is there anything plausibly within either due process of law, due course of law, or law of the land that wasn't already baked into the Constitution itself for the 2.5 years before there was actually a Bill of Rights? And I think when you look at it, the answer is no. Everything and anything that you could plausibly read into that, already there in the original Constitution, and the Fifth Amendment, under any of these formulations, essentially changes nothing. I have an article that says exactly that. I'll send you the citation, but moving on.
All right, Will.
I guess I was going to raise some version of Judd's, Chris's, Gary's, and other points about the way the due process requirement interacts with other versions of the Constitution, including the judicial power requirement. The judges apply law rather than make law. But I guess I just want to reiterate, I think it has important methodological implications for you guys, because the more that these points are true, the more it's not clear there's any important difference between something like due process of law and due course of law. And then the less plausible it is that the selection of the obscure phrase due process of law over the common phrase due course of law was intended to have any difference in meaning. If in fact it had no difference in practical effect, it's a little harder for us to all assume it still had a difference in meaning anyway. It could have, it could not have, but it's not as clear. These things will also matter a lot if you go to the 14th Amendment, where maybe not all of these provisions are guaranteed against the states. States don't have the same separation of powers requirements, but I don't know if you're doing that paper.
I just want to quickly address the question whether or not due process of law is baked into the Article 3 language, judicial power. And I certainly recognize that there's a question there. And in order to answer that question, we would need to offer an account, obviously, of the original meaning of Article 3, which we're not prepared to do in this paper. But I just would indicate that I'm quite skeptical of the view that the communicative content, that is the propositional content conveyed by Article 3, Section 1, includes all of the sort of particular aspects of the way in which judicial power had been exercised and structured at the time. So I admit that there's some possibility that the phrase judicial power was very, very rich, but I am very skeptical of that, and I don't see the right kind of linguistic evidence for that, because this has got to be in the semantics of the period, and I haven't seen this evidence. That doesn't mean that, as a practical matter, judicial power as exercised at the time wouldn't have comported with the understanding we have of the due process of law clause. That's a different question. The clause is not, I think, intended to change things as of the date of adoption. It's intended to guard against future changes. And we believe that the content that it did provide, although much less rich than it would have been had they said due course of law, is nonetheless quite significant as a check on executive power.
I agree with that. And just to respond directly to Will's point about whether there was an intended difference in meaning between due process of law and due course of law, as we highlight in the paper, the New York ratification circular went through a significant editing process in which they began with the phrase law of the land, and then that was edited out and replaced with due course of law. And then that itself was edited out in committee, and in a committee of the whole, and replaced with due process of law. And so this shows that a significant amount of attention was placed on the exact language used in the New York ratification circular. And as we mentioned in the paper, that was the only circular that specifically requested a due process of law clause in the federal constitution. So we think it's worthy of the attention. And so we can't speak to, sadly, no minutes were kept for why these changes were made. So we could, at least that we're aware of. So we can't speak to why, but we do think that it speaks to an intentionality. And certainly, I would be unwilling to state that because of the similarity in just the semantic construction of these phrases, we should overlook the difference in meaning communicative content as we've set out in this paper. Turning to Don Drip's point, which I thought was fantastic, and I just want to start off by agreeing with you. I wish I could have put more stuff, or we could put more stuff in this paper too. I do think that, and without having looked at all of the sources you cited, I can provide a few preliminary comments just based on my recollection of, for example, James Otis's argument, which I believe was very much focused on the meaning of law of the land rather than the meaning of due process of law. And I believe that is true for most of the pre-ratification sources you cited, but please don't hold me to that. But I will say that the citations you provided later on, such as Calhoun's argument in 1836 and Tawney's argument in the 1850s, are both post-date Justice Story's conflation of the phrase due process of law and law of the land. And it is at least conceivable as I sit here that they themselves follow Justice Story's lead. But I agree. I think that there's certainly more to say on this topic. And I hope that we have the chance to engage in it.
So Tara, do you want to weigh in at this point?
I'll just say a couple very, very quick things. So Gary is right, the original Constitution matters more. I didn't mention that I also, in my written comments, include Article 1, habeas corpus, and a few other provisions in Article 1. I do want to say just a gentle thing about the ratification circular. This was the nitpicky comment I didn't bother to mention earlier. I think you guys actually put forth a lot of really, really interesting evidence that due process of law was different from due course of law and of law of the land. I did not find the ratification circular to be the best evidence for you guys, because one could interpret the striking out of course and replacing it with process as saying that there are different things. One could also say that the replacement was made because people thought they were just the same and it didn't matter that much. So I would just be cautious about relying too much on that one piece of evidence.
All right, our next three are Richard Fallon, John McKyle, and Richard Epstein.
So I have a question that I'm afraid is all too predictably entirely or almost entirely methodological. But my concern is the concern about what is it in the world that makes true the interpretation of the Fifth Amendment that you're pressing. So as I understand it, on page 29 of your paper, you say that founding era dictionaries had different definitions of process. One, you narrow as relevant those that have something to do with legal meaning, but you say that there are two dictionary definitions of process, one of which is consistent more or less with modern reading, and then the other one, the more limited reading that you propose. On page 46, you say that at the time of the founding, due process of law was an obscure legal term. And so somehow we get from the idea that we are supposed to understand the Constitution as a public document the way ordinary people reading it would have understood it, to the one true conclusion that due process had the very narrow meaning that you want to ascribe it. And thus, my question is, what in the world is it that makes that true? So in commenting on my paper, Larry, you said you're not concerned with reasonable meaning. You don't want to work with the construct of a reasonable person. How would a reasonable person have understood this? And so if we're not talking about a reasonable person, I assume endowed with some qualities of normative judgment, would have understood this. We've evidently got a factual question about how somebody understood this, or what somebody would have taken the communicative content to mean. And so who's the somebody? What's the evidence about how particular people were understanding it? And then my notion about there just being one true, correct meaning, if there were any number of possible readers, some reasonable members of which set might have thought that the due process clause had the broader meaning or wasn't inconsistent with the broader meaning, then what is it that your bits of evidence are trying to establish? That there were no such dissenting readers, that if there were any dissenting readers, they had made some sort of mistake? If so, what was the mistake? Is history, I find the history interesting, and it's proof of the existence that fairly could be called the one and only true interpretation, original public meaning of the due process clause. I just am a bit perplexed.
Let me start by saying how proud I am of Max, who was the star student in my seminar on the drafting and ratification of the Constitution at Georgetown that I taught with Bill Traynor. It's great to see him and Larry do this work. I am skeptical also, however, and I wanted to just mention some sources of evidence that I would look to if I were going to try to push back on your thesis. So I'll offer these up. Now, with the caveat that I understand that you've hit your word limit and you're not going to be able to do this work for this paper, but it seems to me that you've raised a really interesting question. And if one really wanted to go deeper, there are places to look. So we commonly look to Cook and Blackstone as the sort of seminal sources for where the founders got their common law, but it's not really quite right. I've been losing my eyesight transcribing James Wilson's legal notebooks. So what he was doing when he was under the tutelage of John Dickinson. And there's a little bit of Cook and Blackstone, but most of the entries come from other sources. So, and this is fairly well known to probably many here, Bohun, Dalrymple, Wood, Jacobs, Salkid. There is a lot of legal literature in the 18th century that is very detailed. These treatises are sometimes 600, 700 pages long. And if you really wanted to get a fuller view of what the supposedly technical understanding of these terms was, I think you have to go far beyond Cook and Blackstone. Relatedly, I would encourage you to look at the state case law. So I'm less interested in statutes and would be more interested in the case law, and especially the early American case law. So it happens that a lot of the founders with whom we're familiar, people like Iredell, Patterson, Chase, Sherman, they were the best lawyers in their state, and many of them put together case reports of all of the cases in their states in the 1780s and 90s. You have a couple sites. I think you have a site to Butler versus Craig, and you say something like there's not much case law, but you might at least be able to prove the negative or just to fill out the picture for what the trial lawyers among the founders actually understood these terms to mean. Relatedly, COFEA, it's a nice source, but we need to bear in mind what the data sets are that comprise COFEA. If I'm not mistaken, it's three primarily. It's the Founders Online, It's some libraries of Hein, which is helpful, and it's the Evans newspaper database. But that doesn't exhaust the universe of evidence here. And depending on which Hein data sets are included, it may not be giving you the best information. Of the big six founders, only really Hamilton was a trial lawyer, I think. I don't know how much court work Adams did, but the others, you're not really going to find a lot of discussion of due process of law. And in that whole data set, I would doubt that you would find what you're looking for. But if you looked into the state case law and the treatises that the best trial lawyers of the founding generation actually utilized, I think you'd have a much stronger case. The last point I'll make is that when you look to dictionaries, I would encourage you to look directly and exhaustively at the legal dictionaries. So when I did my work on the original meaning of emolument, I did an exhaustive search of not only all the English language dictionaries, but every legal dictionary from, I think it was 1523 to 1792. There aren't that many. And you could do much more in that direction. I think you have a cite to Cunningham, but why not do all of them? If you're really trying to make this point that the term was a well understood technical term in the 17th and 18th century that would have been well understood by the founders. So I realize that you can't do all of that in this paper, but if you do a follow-on paper or are interested in finding out more about these matters, I really would encourage you to dig much deeper still, even though you've dug quite deeply thus far.
I'm going to approach this as sort of from exactly the opposite direction. My ability to work with original sources is pathetic. So what I tried to do is to spend my time seeing how much you can dredge out of the text in the form in which it's worked. And here it's actually taking a kind of a leaf from Dick Fallon, because I mean, there are minimal and stronger meanings that I could associate with due process without any knowledge of any historiography. So the first of the meanings I think you could say is there is a general set of practices that are required in all sorts of cases. And in a particular case, somebody decides to deviate from that. And one can say, well, the legislature has established the process that's due. There's a deviation in this particular situation. The selection and the exceptionalism are real danger because who's going to do it and why. And so as a kind of a fixed minimum reading, you cannot deviate from those processes that have already been there. I think it's a safe constitutional assumption that such processes have been around for a very long time. But then you get to the second question is, can the legislature simply dumb down the entire system to the point that the only thing that it has to do is to simply write a two-sentence word, we wish to convict you, and the whole case is done? And the word do has an implicit normative meaning in the ordinary language having to do with something appropriate, something fit, something just, and so forth. And so what somebody is going to start to say is, no, the first meaning is a necessary condition for due process. But as a matter of ordinary English, which I think all of us care about, at least to some extent, it's not sufficient to explain what's going on. So then what you have to do is to say a much harder question, what kind of constraints do you start to put on the legislature so as to make sure that you don't have wholesale abuse instead of individual abuse, which is, I think, again, very consistent with the pattern. And at this point, you know, I'm a Romanist by training, and it turns out there are always two principles that everybody seems to believe. Nemo iudex in causa sua, if I got the Latin right, nobody should be a judge in his own cause. And then audi alteram partem, you have to hear the other side. And what I think you can say is those are certainly there. Where the variation comes is where and how you start to give the hearing and so forth. And so I would think that it would fall within the realm of legitimate dispute to say whether or not you have to give a hearing before or after. As one will recall, in the 19th century cases, in tax proceedings, you collect the money and then they have to go for a refund. And I could see why you would want to do that and so forth. But I really find it extremely difficult to believe that there are no notice and no bias provisions that can be read into this if we're going to just talk about this as a kind of service of process situation. So I think once we go beyond the narrow case, we're going to always have to, as we say, slush through a little bit of mud on these things. But I think in this particular case, the next handhold is pretty strong. And I'm willing to live with constitutional indeterminacy about the sequencing, the time, whether it's person or whether it's in paper and so forth, all the kinds of questions that have been raised where I think there is honest disputation. But I'm very hard pressed to believe that you could do without notice and that you could do without the bias proceeding under due process. So I'll stop there.
All right, responses?
So thank you all for the excellent questions. Richard, so I just think your question is asked from a living constitutionalist perspective. You're saying that a modern meaning is semantically available in the sense that the non-disambiguated individual words could be put together in a different way than they were put together at the time. So that
I don't think it's living constitutionalism. I think it's historical constitutionalism.
Just
I'd be
doesn't
stunned if
conform
people
with-
did not think that those were standard uses.
Richard,
Okay.
it just doesn't comport with the methodology that we're employing. Dick, thank you so much for the question. And it gives me an opportunity to say something about how you demonstrate that an originalist interpretation is adequately supported. So the truth maker question. So the kind of argument we are making, and this does need to be in the paper, is an inference to the best explanation or abduction argument. So we have a bunch of data points. We have linguistic facts on the ground. And so which theory of the meaning of the phrase due process of law best explains the instances of usage that we're able to find. So, and our position is that the explanation that best fits all of the data points is the process theory. That's the truth maker, that that the theory best fits the data. You ask some very important questions, and we can provide more clarity in this paper, but what really I need to do is provide more clarity on this in the public meaning thesis paper, because that's the paper that deals with the issues you raise. When I said it's not a reasonable person, I was fairly careful, right? It's not an objectively reasonable person, right? It's not a hypothetical construct. Gary Lawson and I disagree about this issue. So it is actual individuals who are competent speakers. Our question is, how did actual competent speakers who did attempt to read the language actually use the term, right? Or the phrase due process of law. And we don't need unanimous agreement. That's just not the way language works. There are going to be outliers. There are going to be people who misunderstand language. But what we are looking for is consistency in patterns of usage. Such consistency is the way language works, right? The way language works is that there are regularities in usage. They don't have to be universal regularities. And we believe that if you look at for instance, you look at the corpus linguistics evidence and you look at every single use of the phrase due process of law in COFIA, I just think it's dramatic. And I urge everyone who is skeptical about our hypothesis to do that search. Now, John McCall is absolutely right. COFIA is incomplete. They build it out over time. So we would be more certain after the COFIA database is expanded to include as many sources as possible. But I feel confident at this point that the best explanation for the facts on the ground is the process theory of due process. Like all abduction arguments, all best explanation arguments, it doesn't provide absolute certainty. It's not a deductive argument, right? But I would say it's a very strong best explanation argument. Okay, and I'll turn it over to Max.
Great. Well, I'll jump in and just respond directly to Dean Mikhail's comment. And let me just say, Dean Mikhail, it's so nice to see you again. I greatly enjoyed your seminar. And I have to say, as your former research assistant, I certainly appreciate the thrust of your question regarding my methodology. So I'd like to address a few of the points you made up front. Certainly, Cook and Blackstone were not the only sources of legal authority. They were, of course, the most well-cited, and their treatises were the most likely to be in Revolutionary era libraries. But you're absolutely right. And with more time and with more space, I'm sure that we would love to delve into that interesting topic some more. But as to your point on state case law, that is, I think, essential. And I think that perhaps that part of our paper could be better framed. And what I mean by that is that while we did survey state case law to determine how it was, how states were interpreting the phrase due process of law, we didn't highlight that as much as we could have. So I'd direct the reader to footnote 290, where we talk about how states were interpreting their constitution's law of the land provisions with reference to the meaning of due process of law, to understand that law of the land required certain procedural requirements, to strengthen their interpretation of the law of the land as providing checks against the legislature. They would rely on the meaning of due process of law in reaching that conclusion. And while we don't necessarily endorse that reading of the meaning of due process of law, we do think that is important evidence of how these state courts understood the relationship between law of the land and due process of law. Clearly, what they understand is, or as we interpret these cases, they understand law of the land to be more encompassing and to encompass the meaning of due process of law, much as we've argued. Your point on COFIA is extremely incisive, and I couldn't agree more. We note in the paper the very few number of irrelevant results we got when we did a search for process. What I mean by that is that despite the fact that process has a large number of non-legal connotations, and just sitting here, common sense would say that the majority of uses of the phrase process in everyday language is not legal. What we found was that very few of the results in our databases were non-legal. They were almost all entirely either references to writs or references to courtroom procedure. We break down the numbers in the paper, but this certainly suggested to us, and as we commented in the paper, that COFIA is at least biased towards legal meanings based on the databases it draws from. But I couldn't agree more that, as Larry agreed with you, there are certainly limitations from using that database, and we don't mean to overstate the power of the results that we drew from that. Finally, you commented on our surveillance of legal dictionaries. I couldn't agree more, and honestly, a few more days delving through legal dictionaries from the 1500s sounds like a dream. But what I will say is that we had to narrow the scope a little bit. And so what we did was we drew all of the, we looked to a paper by Gregory Migg. I'm sure I'm not pronouncing that name correctly, and I apologize if I'm not. But he set out a list of founding era legal dictionaries which have been cited by the Supreme Court. And so we used that as our baseline and surveyed each of the dictionaries that he recommends as an appropriate study for this. And we don't pretend to say that these dictionaries have a special significance or that they are somehow more explanatory than other potential dictionaries, but simply as a starting point, we felt that was a good place to begin our research.
Larry and Max, I love this piece. I'm really excited about this project, and I think you're making some really important contributions. So I'll throw a few bulleted thoughts out there. This isn't meant to suggest, I think, that there were any errors, but just since you mentioned you're going to be thinking about the corpus linguistics stuff a little bit more, these are some other things to think about. I wonder if it would be worth looking at collocates of the word process, just to see what other sorts of terms are coming up with any sort of statistical frequency with that word. I also wonder, given some of the limitations we're talking about with COFIA, if it would be worth looking at the COEAN database. For what it's worth, this goes to another point you're making about whether or not this was a frequent or a rare term. That sort of depends on compared to what. I mean, Kurt Lash has made this point in his recent Bill of Rights paper, but if the volume of stuff we have in America at the founding period is just lowered, then we'll expect that actual phrases might come back with less frequency in COFIA than perhaps other databases. I found that to be true in a different project I worked on, for example. So something to just maybe think about when you're saying it was a really rare term. And then for what it's worth, I did have the same question that Tara had about Adirond. I think that's an important implication. If you have space to address it, that there's a lot of good reason why you may not have space. So well done on this great project, and good to see you.
So yes, I have a thought or two about writs. You emphasize just how narrow your interpretation of due process is, but I wonder if it doesn't entail just a bit of substantive review owing to the nature of what writs were. You described writs, or the requirement of a writ, as a process guarantee, a minimal separation of powers guarantee. A writ issues from a court. Well, yes, but each writ also defined the scope of the suit. Each writ had a set of elements that needed to be satisfied for somebody to be held liable under the writs. Those elements aren't satisfied, you can't have your stuff taken. So a judge has to determine whether those elements are satisfied. Now, suppose you have a statute that supersedes a writ. You've got to determine whether that statute is lawful in order for that to happen. And then you need to determine whether the Constitution authorizes the statute. And then due process of law may entail some form of means-ends analysis, substantive analysis of federal statutes. Because, as you say, it guarantees the rule of law, and the rule of law requires a valid law. So perhaps even if your interpretation is narrow in the first sense, it still entails substantive review unless there's a conception of a writ operating that may just be a little bit too narrow.
John?
Maybe law of the land, due process, vested rights both emerged because they believed in vested rights.
Thanks to all of you. That was wonderful.
Yeah, thank you so much.